E ku iluna. Please rise. Ahea oko eko ka aha, inahe kuliana imu o kia aha ho o kolo kolo ki ike hanahano o kumoko aina o Hawaii. Inai mai, e malio mai, ilohi ia kaleo. Hear ye, hear ye, hear ye, all persons having any business before this Honorable Supreme Court, State of Hawaii, draw nigh. Give your attention and you shall be heard. Inoho ilalo. Please be seated.
Please call the case.
Case number SCAP-24-0000401, Leonard K. Nakoa III et al., Plaintiffs' Appellants versus Governor of the State of Hawaii and Hawaii Housing Finance and Development Corporation, Defendants Appellees. Arguing for Appellants, Lance Collins. Also appearing, Ryan Hurley. Arguing for Appellees, Ewan Rayner. Argument on the merits.
All right, good morning. Aloha, everyone. Our proceeding today is being broadcast live on the Judiciary's YouTube channel as well as on Olelo. Counsel, are you both ready to proceed? Or Mr. Rayner? Okay, we've allocated 30 minutes for each side. Mr. Collins, at 15 minutes, we're going to give you a warning light so you can reserve time for rebuttal if you want at that point. And Mr. Rayner will give you a warning with 5 minutes to go. Mr. Collins, please proceed.
Aloha, ai olo olo ai ka'aha o kolo kolo kie kie. Aloha, and may it please the court. This case is about the limits of emergency power under HRS Chapter 127A. Appellants challenge the governor's authority to declare the shortage of affordable housing a statutory emergency, and through that declaration, suspend laws and implement a new policy regime. Chapter 127A does not authorize those things. It permits the governor to respond to emergencies, events or occurrences that threaten life or property, not century-long elements of our current economic system. Nothing in the statute allows executive declarations to bypass the legislature when the legislative process disappoints. That limit is not only statutory, it's constitutional. Article 1, Section 15 of Hawaii's Constitution, adopted shortly after the abuses of martial law, strictly limits the suspension of laws to particular cases expressly prescribed by the legislature. The housing proclamations do not meet that standard. The power to declare an emergency is, at its core, a legislative power. It determines when ordinary lawmaking processes may be suspended and under what conditions. The legislature may delegate that power, but only in particular cases and subject to clear limits. Whether a situation rises to the level of a legal emergency under that delegation is not a matter of executive discretion alone. It is ultimately a judicial question because it defines the boundaries between lawmaking and execution. Courts have the duty to say when that line has been crossed. This case is not occurring in isolation. Across the country, we are witnessing a growing trend of invoking emergency powers to bypass legislative deliberation, not to address urgent, time-bound disasters, but to pursue major policy goals unilaterally. At the national level, we've seen emergency declarations used to redirect military funding for border construction, to deport individuals without due process, and to impose sweeping economic measures. These are not unforeseen disasters. They are contentious policy debates that belong in legislatures. The same risk is present here. The housing shortage is real and serious, but it is not new. It has been the subject of territorial and state legislation for decades. The governor's actions, suspending laws, creating new offices, shifting permitting authority, are legislative in nature.
Mr. Collins, what about a situation in which there's a sort of explosion of unhoused people in a particular part of the island in an effort by the governor to declare that particular situation an emergency and try to use the powers provided under that declaration to have those folks be able to get them housing on an expedited basis? Is that more narrow use of the power? Would that be problematic from your point of view, as opposed to the broad, all housing across the state nature of this declaration?
I think it would depend on whether or not there was an event or an occurrence in your hypothetical. One thing that does happen is some of the counties use what I think is colloquially referred to as a sweep. It's a sweep. And so if you sweep an area and then all of a sudden all of the people that were living in one area suddenly move to another area, is that an event or occurrence, or is that really just the consequences of a policy that isn't an event or occurrence? So I guess it partly depends on what the specific facts would be in that particular situation.
Counsel, can I just pick up on that? Can't you have a situation where you have something that's festering over time, like this housing crisis or what's been deemed a housing crisis, and then it hits a critical mass? If you have half the population one day homeless, why wouldn't that constitute an emergency as contemplated under 127 alpha?
If it were an event or an occurrence, you're saying one day, but the proclamations that we have before us is just talking about general trends of what's been going on for.
But doesn't it infer that it hit a critical mass? Instead of 4,000 units a year, it's up to 10,000, more than doubled? Isn't that the crisis that's been articulated in the proclamation?
Well, the proclamation doesn't identify an event or an occurrence. It just says that it's a state of affairs. And I think as we've noted, without the limitation of there being an event or an occurrence of a natural or man-made disaster, what 127A would give the governor powers that are not permitted under Article 1, Section 15. I mean, the issue here really is, if there were some, imminent, some event or occurrence that created an imminent danger to life or somebody's liberty, that may constitute an emergency. But if we're talking about something where, let's say, the governor could call the legislature into special session, it's not clear why that would not be used, as opposed to allowing the governor to basically declare anything an emergency.
Are you aware of the legislature taking any steps to respond to any of these proclamations to rein in or curb what the governor has been doing?
The legislature, as far as I understand, has not amended 127A. And that is something that Judge Cahill did mention, I believe, in the last hearing that we had before him, that he had based his ruling in part that the legislature's, I guess, implied acquiescence to what the governor's, and it's not just the current governor, the previous governor, sort of using the proclamation power in this way.
Mr. Collins, I think in the 2024 session, in fact, 127A was amended, particularly the provision that provides 127A14, the provision that provides the governor shall be the sole judge of the existence of the danger, and what they extended there was also that the governor should be the sole judge of an extension or a termination, which was the issue in the R. Wrights case. So I think, to Justice Devin's point, I mean, the legislature certainly has the ability, and in fact has looked at the scope of the governor's powers under 127A since these proclamations, at least the initiation of these proclamations, occurred, right? Because wasn't it July of 2023, I think it was?
Yes.
First? Okay. So I think there was something in 2024 session. And in fact, there was another Act 237 in the 2024 session, which actually, this one limited the governor's power to suspend electronic media transmissions during a state of emergency. So I guess the point is, the legislature certainly has been active, continues to be active. There were other bills in the 2025 session. Why isn't that the appropriate remedy here?
Well, our position is that Article 1, Section 15 specifically limits the legislature's power to delegate. It has to be expressly done under particular cases. And so if the legislature doesn't do anything, they're not expressly doing anything. And so the general thing, well, we can say the legislature is acquiescing to what the governor is doing, doesn't provide a sufficient basis for the governor to act contrary to
That goes back to the actual interpretation of 127A, right? I mean, really what we're talking about is, did the legislature intend to give the governor and the mayor, to the extent that the provisions are similar, these kinds of broad powers as to declaring an emergency? And there certainly is express language in 127A as to the comprehensive sort of authority that's being given under the chapter, right? So we're dealing with the statutory authority. Wouldn't you agree? Like if the statute does provide the governor the authority, then the constitutional issues are not violated. Would that be agreeable to you?
I think our position is that if the statute, our position is that the statute doesn't give the governor that power. But if the statute could be read to give the governor that power in this instance, then it would be a violation of Article 1, Section 15. Then it would be unconstitutional.
I'm sorry, could you repeat that?
So our argument is that if our position is that the governor's use in this instance, or in these instances, there's 13 proclamations, that violates the statute. It exceeds the authority of the statute. But if the statute can be read to allow the governor to do that, then that would violate Article 1, Section 15. Because if
the legislature intended to give the governor the authority to do what the governor did here, your argument is that the Constitution would prohibit them from doing that?
Yes, because Article 1, Section 15 says that it has to be in particular cases and expressly stated by the legislature. And so if emergency can be defined to mean whatever the governor wants it to mean, as opposed to the language in the statute, then we've extended beyond the final limit of particular cases expressly prescribed by the legislature.
Well, it's not whatever the governor wants. There's definitions of emergency, disaster, hazards. The legislature gave those definitions.
Yes, Your Honor.
And it's not an unbridled authority. It's only to suspend laws that impede the ability to address the emergency. Isn't that the guardrails that the legislature put in place?
I think the definition of emergency, could be argued to be a particular case, although it's very, very broad, and maybe there's a question about whether, we're not raising that, but I think in a sort of abstract sense, there's a question about whether the emergency management statute, just on its face, actually complies with the particular cases. But presuming that they can do that, emergency is defined as an occurrence or an imminent threat thereof, as opposed to a state of things. So that's the problem with this particular case, is that there wasn't an event or occurrence, say like the Lahaina fire or this COVID-19's introduction into Hawaii. There wasn't some event or imminent threat of an event.
Along those lines, if I may ask you, I'm just curious what your take is. You got the proclamations that related to the access deer situation, and that didn't happen overnight. That happened over time, but it seemed to reach a critical point that action had to be taken. Would you agree that that was a proper or improper use of the 127A powers by the governor?
Well, as somebody who has access deer that come by my property regularly, I definitely is a nuisance, and for my neighbors who are farmers, they have definitely suffered through that. In my view, though, I don't think that the access deer matter is an emergency as it's defined under Chapter 127A, and it probably is something that the legislature should be the one to address, as opposed to through proclamations.
I'm so sorry. You finish your answer. I didn't mean to cut you off.
No, Your Honor, I was just saying that would be something that is appropriate for the legislature to address, as opposed to the governor creating a parallel regulatory regime to try to handle deer.
So what about the proclamation relating to medical transport aircrafts and crews after a tragic crash off Maui back in December of 22? The governor declared an emergency and suspended various laws related to licensing, registration requirements to allow out-of-state folks to come in, I guess, to fill the need for air ambulance services in the state. Would that be, because that's a particular event, that would be an occurrence in your mind, or would that be, and therefore proper or improper?
Well, Your Honor, I'm not very familiar with that particular proclamation, but if there was a airplane accident that basically rendered emergency services unavailable, that sounds like it was an event or occurrence that meets the statutory definition of an emergency.
Actually, doesn't 127A1 apply to the disasters and emergencies? And isn't disaster defined by 127A2? Means as any emergency which results in loss of life and requires or may require assistance from other counties, et cetera. I mean, it seems like that an airplane disaster that results in loss of life or possible loss of life is something that is expressly covered by the statute.
Yes, Your Honor, and the statute also says that the suspending of laws are limited to suspending laws that would impede the ability to address that emergency. So if in fact that's what happened in 2022 with this plane disaster, it seems like it fits within the definition of an emergency under the statute, but not knowing the full case to be able to say with certainty.
I'm so sorry. I'm curious what you think our standard of review should be here for, I guess, in a broad sense. In other words, are we just doing a sort of just a strict statutory interpretation, or given the language of the statute itself, the chapter overall, is there some deference that should be given to a governor's determination that there is a state of emergency?
Your Honor, our position is no, and we cited the case Territory versus Yoshikawa. And in that case, of course, that was addressing the legislature's determination of emergency. In this case, the legislature has delegated that power to the governor, but it's still a legislative power. And in Territory versus Yoshikawa, the Supreme Court said that the determination of emergency is not conclusive on the court, but it's actually the starting point for an analysis of whether or not an emergency exists.
A lot of the cases around the country, especially during the COVID period, in looking at emergency proclamations by governors across, many jurisdictions, talked about sort of an arbitrary and capricious sort of standard or a deference type of standard. What do you think about that? I mean, why and I think because there is language here suggesting the legislature intended the governor to have broad powers.
Well, Your Honor, about other jurisdictions, I can't totally speak to that. I know from what I've read that in 1950, our Constitutional Convention delegates had just been through a several-year martial law period that was rife with abuse by authority, and that was because the governor just decided, without informing anybody, on December 8th, 1941, to hand over all civilian control to the military. And so I don't know about the other states. I don't think that they necessarily went through that when they were drafting their constitution. But Hawaii had that experience, and then that, of course, built upon the experience during the so-called Republic period, where martial law was declared specifically so that the people in control could target political opponents.
Mr. Collins, going back, I guess, to the roots of the statute, the provision regarding judicial review and suggesting that if there's an action for TRO or injunction, there needs to be a 3-judge panel established. I believe that goes all the way back in the prior statute to 1950, so it's been around for a while. The state's argument is if we allow a declaratory judgment action, in essence, it's circumventing that very expedited and also very clearly laid out process for challenging actions taken pursuant to this act. And what's your response to that?
Well, Your Honor, actually, our view is that the declaratory judgment route or quo warranto route is actually much more deferential to executive authority than seeking an injunction. So an injunction is a specific type of remedy, and it basically is asking the court to immediately stop the executive branch from doing something. But with a declaratory judgment or with quo warranto, it's simply asking the court to determine what the law is and allow the executive the first opportunity to figure out what to do once the court has declared what the law is. So in our view, well, first of all, our view for 127A27 is that that does not define the cause of action to challenge anything under 127A, but instead it specifically addresses if you seek these extraordinary remedies, then you need to have the three-judge panel appointed. And I believe that a three-judge panel was appointed when Governor Ige declared an emergency on top of Mauna Kea. And of course, those judges ruled that the emergency was improper and restrained Governor Ige's use of it. And that there was an immediate need, I think, for the plaintiff in that case because his constitutional rights were being invaded presently when he filed that suit. Whereas in this case, when the case was filed, if the circuit court had ruled in our favor and declared what the law is, that would have given the governor the opportunity to adjust or figure out what to do next without having the court tell the governor what to do.
As the petitions, or pardon me, as the declarations went on from the first one to the fifth one, the scope of, I guess, what was being suspended and what was being put in its place seemed to narrow. Did it come to a point where any of the provisions in the proclamations were not objectionable in at least some instances, or even the fifth proclamation would be something that you think is an overreach?
Well, plaintiffs' concern, even with the narrowing down of exemptions and rewrites, there are several core laws that were never addressed. One of them has to do with planning and zoning and the fast track provision. One has to do with civil service, and one has to do with public procurement. And of course, the school impact fees. And those are of great concern. And I think if people who are, observing what's going on nationally, people don't really realize how important the civil service is until you start having people firing people for political reasons en masse from the civil service, or you start issuing no-bid contracts or appointing people who then award themselves contracts from the government. And then you start to realize how concerning it is. And so that one of the concerns is, at this moment, it may seem relatively benign, but actually very quickly it can escalate into, if there's no bounds to the use of this power, it can quickly escalate into things where you have the richest man in the world, suddenly a special government employee firing dozens and hundreds and thousands of civil servants.
In this particular case as it stands now, do your clients is there a concrete or defined enough dispute between your clients and the state to give you standing under, or to give them standing under the declaratory judgment action statute?
Yes. As to the fast track statute, the plaintiffs in this case do have a First Amendment right to petition the county councils. It's statutorily defined. And by shifting that over to the HHFDC...
I mean, that's more of a procedural due process issue, isn't it, than a First Amendment issue?
Well, the First Amendment issue is that they have the right to petition the government.
Is 46.4 a law relating to environmental quality?
Our position is yes, Your Honor, it is.
Why?
46.4 is the power given to local government to comprehensively plan and then implement those comprehensive plans through zoning and so forth. And it is the local implementation of Chapter 205, which is the state land use boundary statute, which is a law related to environmental quality.
If there's a private right of enforcement for any zoning matter under 46.4, does that mean that any given project relating to zoning has a right of action for any given person?
Well, I don't have the cases in front of me, Your Honor, but I believe that this court and the ICA have somewhat it's a little bit different than greenhouse gas emissions, which are basically everywhere and impact everybody.
It seems different than 205 as well. But if you are suggesting that 46.4 is a law relating to environmental quality, and then there's private rights of enforcement, then it would seem that, you know, somebody doing some sort of a zoning out in Laie, for example, somebody from Hawaii Kai that has no relation to it can challenge that zoning matter?
Well, Your Honor, I'm not entirely sure about that because, as I said, I forgive me
Isn't
that I
the
don't have the
distinction? Isn't the
cases.
distinction here in this particular case is the whole darn thing 46-4 is being suspended? That's isn't that a key point here?
It's partly it's suspended, but partly. But then the problem is that the governor has basically created his own thing and is implementing it, and there's no statutory authority for that at all.
Let me ask you this, sort of segueing into that. You know, the state almost suggests there's really no right to judicial intervention, but I'm wondering about factors with respect to the emergency, whether they should be considered. Things like, you know, the duration of the emergency, the nature of the threat, the proportionality of the response. Are all those things something this court should consider when we are looking at whether indeed there is an emergency?
Yes, Your Honor, and I think we cited Duncan versus Kahanamoku, and elsewhere in that decision, the court there said that that when courts are open, that is not the proper. It's not proper to basically be trying people by military tribunal. And I think in our position, in general, is if the legislature is able to convene, you can't have a 5-year regulatory regime called an emergency simply because the legislature doesn't want to take action, or the governor and the legislature have agreed that the legislature is not going to take action, or something along those lines. So I think that the reasoning in Duncan versus Kahanamoku about if courts are open, you can't be trying civilians in military tribunals. And very similarly is what is an emergency and what can be done in an emergency is in some ways limited by the ability of our lawmaking branch of government to be able to do its job. The whole purpose of emergency powers is because of these sort of sudden and unexpected activities, events and occurrences that occur that cannot be addressed through the normal lawmaking process.
So if there were a catastrophic hurricane hit portions of Oahu in the fall, and the legislature could convene in January in regular session, your point of view is that the emergency authority shouldn't extend beyond that legislative session, that the legislature should step up and address the issue? Because I heard you say if the legislature is able to convene, shouldn't be a 5-year crisis. So is there some flexibility there for the executive branch to keep taking action, or is it literally next session of the legislature cut the power?
No, Your Honor, and it really depends on exactly what the facts of the emergency are. But at some point, you know, the emergency proclamation process just basically becomes this parallel regulatory regime, and that seems to exceed the authority that the legislature can delegate to the executive. But it's not present in this particular case. But I do think there is some outer limit to just having an endless state of emergency. And it's very much based on what is the emergency, because the statute itself says that you can suspend laws to the extent that they impede the emergency management functions.
Well, and that's the duration, right? I mean, there's sort of, well, you keep talking about an event or occurrence, but there's also got to be some sort of an endpoint too, right? To align with your argument on the narrow scope of 127A.
Yes, Your Honor, and that is actually something that, in our view, the legislature should really be the one to craft this.
So given an open-ended situation, that is more proper for legislative action.
Yes, Your Honor. And I would like to, if I could, reserve a few minutes for a rebuttal. Very well. Thank you.
I'm sorry, Chief Justice. May I just one
please,
last,
yeah.
just a sidetrack a bit, Counsel. You know, in your quo warranto claim, what's your position on that? Because the case law seems pretty clear that once you amend, your amended complaints becomes your sole statement of your case, and that your prior original complaint has no further effect.
So, Your Honors, we cited Ninth Circuit precedent that where the trial the claims were not voluntarily dismissed, but were basically dismissed by the court, that counsel should not be put in a position of either having to waive those claims later or potentially be sanctioned by the trial court. And Judge Cahill expressly said in the hearing, you can move for leave to amend your complaint, but don't include the quo warranto because I've already ruled against that. So if we were to do that, I'm pretty certain we would have been sanctioned. And if this court hasn't, it should adopt the analysis of the Ninth Circuit with respect to that.
And actually, in the state really, in terms of Hawaii law, cited to the beneficial case. And the beneficial case is clearly distinguishable because the issue was whether or not the defendants were asserting that the original complaint was never served on them, and therefore the First Amendment complaint service upon them of the First Amendment complaint was not effective. And the beneficial case cited to White versus Lum, which is makes it pretty clear that the filing of the amended petition complete in it itself and not referring to any other prior pleading without objection by the respondents took the original petition out of the record, and the amended petition became the sole statement. So there was no objection. So White seems to be saying that if there was an objection like there was here, the objection to the dismissal of the quo warranto claim, then the amended petition does not supersede your right to appeal that denial of the dismissal of the quo warranto at the time.
Yes, Your Honor.
All right, thank you, Mr. Collins. The court will give you additional time for rebuttal since we asked you plenty of questions during the time you were, I think, hoping to save for rebuttal. So we'll give you some extra time.
Thank you.
Thank you. Mr.
Good morning, Your Honor. Sorry.
Oh, please go ahead.
Good morning, Your Honors, and may it please the court. My name is Ewan Rayner, arguing on behalf of the defendant, Governor of Hawaii, and Hawaii Housing, Finance, and Development Corporation. Your Honors, there are obviously a number of issues that have been raised in this case, and some of them are procedural or quasi-jurisdictional issues, and I'm happy to answer any, or try to answer any questions the court has on any of those issues. What I'd like to do, if I may, is to first address argument of the plaintiff lacks standing to obtain declaratory relief in this case under HRS 632-1, and then to try to get to the heart of this case and address the merits of the question as to whether the governor's exercise of the emergency authority in these circumstances was proper. So plaintiffs lack standing, in our view, to sue for declaratory relief for two separate reasons in this case. So first, declaratory relief under HRS 632-1 is barred because the Emergency Management Act, and specifically HRS 127A-27, expressly provides a specific procedure to challenge emergency proclamations. And second, even if Chapter 127A does allow for declaratory relief actions under HRS 632-1, the plaintiffs here have not met the statutory requirements for standing to obtain that relief. So in Alakai Nakeki versus Marayoshi, this court stated that where a statute sets out an express and specific procedure by which a party may obtain judicial review, the party cannot circumvent that procedure by attempting to obtain judicial review through the use of HRS 632-1. In our view, that is exactly what the plaintiffs would be doing here if they are permitted to obtain declaratory relief. And HRS 127A-27 bars that declaratory relief because it is a specific...
But are they seeking an injunction here?
Well, we believe so, yeah. In paragraph D of their prayer for relief, they appear, even though they haven't expressly styled it as quote-unquote injunctive relief, they do appear to be seeking relief to help enforce a declaratory judgment. Which,
does 127A-27 allow for permanent injunctions?
So 127A-27, and I acknowledge the title of that provision is preliminary injunction and temporary restraining orders. Now, and to be completely candid with the court, I've read this section 1,000 times, and I think that the key part of that sentence, for the purposes of your question, is the final sentence, which states that it applies not just to applications for preliminary injunctions and TROs, but also to the final hearing of any such suit. Now, I think there's only really two different ways that that language can be read and interpreted that make any kind of logical sense. The first is that maybe the legislature intended for preliminary and temporary restraining order relief to be the sole relief obtainable when challenging an emergency proclamation. And the second reading, I think, is the only other reading that makes any sense, is that the legislature intended that any injunctive relief, including the final hearing on of a suit challenging an emergency proclamation, is also subject to the requirements, the three-judge panel and the expedition requirements of 127A-27. And I think below, at the hearing on the state's motion to dismiss the amended complaint for declaratory relief, plaintiffs' counsel essentially acknowledged that if they were to seek injunctive relief in this case...
But that statute, that last paragraph, it talks about temporary stays or suspension, and it says if there had been a temporary stay or suspension, it has to be set for hearing within 5 days, and then when the matter comes on for hearing, the party who obtained the temporary stay or suspension shall proceed with the application for a preliminary or interlocutory injunction. Otherwise, the temporary order shall be dissolved, and no extension of time shall be granted without approval and upon the final hearing of any such suit. Such suit is pertaining to the application for preliminary or interlocutory injunction, not to a request for a permanent injunction.
And I agree, on first blush, that's how it sounds reading that provision. I mean, but our view is that it essentially leads to an absurd result, because it doesn't appear to make any kind of rational sense for the legislature to require that procedure in a final hearing where the court had previously issued a temporary stay, but not in a case where the court hadn't done that. There doesn't seem to be any rational difference between those two situations that would require a three-judge panel in one, but not the other.
But the section also starts with, notwithstanding any other law to the contrary, no preliminary or interlocutory injunction or TRO shall issue unless you follow this process. So it says notwithstanding under any other law to the contrary. It says you can't get a preliminary or temporary injunction without following this three-judge procedure. It doesn't say this is the sole and exclusive remedy to challenge emergency proclamations.
Right, but it does also say that in that same procedure applies to the final hearing of any such suit. And so the way the state reads that...
Such suit, I understand, but the
Right.
specific language relates to preliminary or interlocutory injunctions. It doesn't even allow for a permanent injunction under this statute.
Right, but I think if we think, and as I said, I think plaintiffs' counsel acknowledged below that if they were to seek injunctive relief, even, in support of their declaratory relief, they would be required to go through that section. And I think if we think through logically how that would work as a procedural matter, it would essentially allow the declaratory relief to completely undercut the purposes behind 127A.
Well, actually, while the declaratory judgment action is proceeding, as in this case, the emergency proclamations remain in effect. And if this court were to rule that there was standing and that these temporary proclamations for affordable housing did not comply with Chapter 127A, then if they continued, as they say, continued to seek injunctive relief, then it appears they might have to go. In other words, if the state refused to abide by this court's declaration that 127A does not allow this, then I guess the plaintiffs would have to seek at least temporary injunctive relief in the trial courts. It's a kind of a strange procedure, but this seems to allow for an expedited determination.
Well, and I think part of that as well is because of the nature of emergency proclamations. I mean, this 127A, mandates that emergency proclamations automatically expire after 60 days. And so even though, in the 4 Arts case, the ICA upheld the fact that the governor had the authority to declare a new emergency based on the same set of facts, as this case demonstrates, even if that happens and an emergency is essentially renewed for another 60 days, the proclamation will often change, as it has in this case. As the situation on the ground changes, the type of emergency response needs to be different. And so you're then left with a case that every 60 days, it's possible that the claims will become moot or stale, which I think is another reason why the legislature, determined that there was a need for that kind of expedited review that they set forth in 127A-27. But I do want to make the point as well that even if declaratory relief is available under HRS 632-1, available in the sense that it's not precluded by 127A-27, we believe that the plaintiffs here have not established the statutory requirements for standing to obtain that relief. Just looking at the complaint, and the circuit court here addressed this on a motion to dismiss. So we were looking at the allegations in the complaint. Now, the first matter, the allegations in the plaintiff's complaint, the only 2 paragraphs where they assert or attempt to allege any basis for the required concrete interest to obtain declaratory relief is in paragraphs 15 and 16. But plaintiffs essentially just conclude without any supporting allegations that they have interests in the suspension of laws relating to environmental quality and an interest in their First Amendment rights to petition elected officials. But the amended complaint doesn't even cite which provisions of the emergency proclamation that the plaintiffs believe would impact those alleged concrete rights. And so the circuit court was well within its rights to dismiss the case based on the bareness of those allegations alone. But even if the court takes into account the arguments plaintiffs have made in their briefing, beyond what they alleged in their complaint, even though plaintiffs don't have to establish the traditional 3-part injury and fact test, they do still have to establish some right or privilege, which
did the original proclamation suspend at least some provisions within Chapter 205?
Yes, but as we've argued, that the claims as to the original proclamation we believe are moot, and the court should be looking at the proclamation that was in effect, when the amended complaint was addressed by the circuit court. But even if the emergency proclamation suspends or implicates statutes that, as plaintiffs allege, define a right to the clean and healthful environment, the bigger problem for plaintiffs is that the statutory suspensions in the emergency proclamations, they're not blanket suspensions. They apply only. Especially the suspensions don't have any effect until they're applied to a particular affording housing development that has been certified and approved by the Hawaii Housing and Finance and Development Corporation. So without identifying any specific certified development or approved development to which these suspensions have actually been applied, the plaintiffs' claims are essentially entirely in the abstract. They cannot have a concrete interest in a suspension that doesn't exist. And so we believe in order to get to establish standing under 632-1, plaintiffs would actually have to identify some way in which these suspensions have been put into effect, and they just simply haven't done that.
Getting to 46.4, all a loop, 46.4 contemplates the conservation, protection, and enhancement of natural resources. It's talking about 205. And, 205, like 46.4, relates to zoning. And then if you look at 46.4, the law that was suspended, it promotes the orderly development of each county in accordance with long-range comprehensive general plans. It's talking about most beneficial use. There's references to wetlands and habitats for protected and endangered species. How is 46.4 46-4 not a law relating to environmental quality?
Well, I mean, we don't believe that it is, but I would just want to re-emphasize that our argument is not really.
But why don't you believe it is?
I mean, because I think it goes back to the point that you made in your earlier question to Mr. Collins, and is that if it is recognized as such, then essentially any individual would have standing to challenge any zoning action under that chapter, which is a staggeringly broad basis for standing.
Under the circumstances of this case, not just somebody challenging, some person across the island's zoning matter, this case had a suspension of a law. Doesn't that circumstance suggest that 46-4 should be into play?
Well, I think that, assuming that 46-4 is a law relating to environmental quality and defining that right, if it was a total blanket suspension on across the whole island as to all development, as to all zoning, then that would certainly be a much stronger argument that that's the case. But, as I mentioned a few minutes ago, the biggest problem, I think, for plaintiffs is that the suspensions in the emerging population are actually very modest. They're not blanket suspensions. They apply only to the extent that a particular development that's been certified by the Hawaii Housing Finance and Development Corp. When that's been certified, then those suspensions can come into effect.
You're talking about the amended proclamation. Would you characterize the initial proclamation as modest in scope?
I mean, I am talking about the present proclamation, and then the original proclamation certainly runs into those problems to a much greater degree.
You can say it. Is it modest in scope?
It's definitely less modest, I will say that.
Does 201 do the most recent proclamations expand on what HHFDC is purportedly authorized to do under 201H-38?
No, the proclamations actually changed very little since, I believe, was the third proclamation that was in effect at the time the Circuit Court heard this.
But did it? There was still the working group and things like that under that, right? Or is this working group still in effect?
I'm sorry.
That working group, is it still in effect?
I'm sorry, one more time.
Is the working group still in existence?
Oh, no, the working group is not.
I thought that didn't go away until about the fifth proclamation.
Okay, so, I mean, I'm not sure how that changes the analysis as to whether the plaintiffs have standing under 632-1.
Who would, in the state's view, who would have standing to challenge challenge these proclamations?
Well, I mean, someone who could identify a particular housing development that in some way affects their interest.
Who would that be?
It could be someone who lives very close to the development. I don't know, without discussing specific facts, I can't say exactly who that might be, but I think at minimum, there would have to be someone who could allege a specific development or a specific suspension of one of these statutes that plaintiff claims are impacting their concrete rights as to how that impacts that right. And the plaintiffs here have not been able to do that. And that comes back to the fact that the suspensions, they're not automatic blanket expansions. They only come into effect once the project is certified. And so if, as the plaintiffs have done here, they attempt to challenge that before that happens, they're essentially challenging a suspension which doesn't really exist yet. Given that my time is getting on,
Counsel, I'm sorry, can I just ask you this question to follow up on what Justice Edens had mentioned earlier about, a starting point and an ending point. For this purported emergency, how will it be determined that it's over? Like for COVID, we had rate of infections that we could follow and see a decrease. so we could go back to our normal lives. But is it number of units that are built, or what's the end point on this?
Well, so there's three ways the emergency can end. One is that at the end of one of the 60-day periods, the governor determines that there doesn't need to be any further emergency proclamation, and in which case it would automatically end. The second is that the legislature in 127A-14, the governor can declare the emergency to be over in his discretion.
How will he do it in this case?
How
Of
would
a housing crisis, that emergency consisting of this housing crisis is over.
Well, that question is given to the discretion of the governor to determine when those circumstances that he has identified as constituting an emergency no longer constitute the emergency and no longer necessitate the emergency response. So that is a question that, like the declaration of when the emergency starts, is given to the governor. But there is one other way. I mean, the legislature always will have the authority to end an emergency. I mean, the legislature can convene either in special session or in a regular session, and it can pass a law which would, in effect, end the emergency or prevent the governor from extending the emergency anymore. And so, to the extent the legislature felt that was necessary, that is something that it would still have the authority to do as well.
Okay, so you don't know how that will be determined, though. That's my question.
Well, I mean,
I know who can do it, but how is that going to be determined?
The
Otherwise, this
question
can go on
would be
forever.
when the governor determines that it is the housing crisis no longer is a sort of immediate threat to the public safety to the extent necessary for there to be an emergency. It's that, and the governor uses the definition in 127A-2 to determine when an emergency starts and when an emergency ends. And so in the governor's discretion, when that point occurs is when the emergency would end.
Thank you.
I think where Justice Devins is getting at is the very sweeping definition of emergency that's implicit in these proclamations. A corollary of that is it's hard to tell when that emergency is over. If the emergency wasn't triggered by some specific event, there wasn't a hurricane or a pandemic that swept into our state, when we all know when the first known case was, but rather an ongoing problem of perhaps 100 years in duration. Very hard to define when the end is, and that would seem somewhat problematic, though, in terms of being a very expansive reading of the governor's power.
Well, I think on the flip side of that, the fact that it's very hard to determine, is that it's very hard to determine when an emergency starts in the first place. I mean, it's essentially the same question, but in reverse.
And I'm sorry to interject, but I guess what everybody's getting at with this line of questioning is that duration does shape the definition of emergency. And I think what you were just getting ready to say is there might not be a fixed starting place, but with a lava eruption, a tsunami, a hurricane, COVID, a global, deadly virus, I mean, they have, clear starting points and a fixed ending point for the most part. But here we have just this expansive duration, and I think that's what should shape, the definition of the governor in his or her sole judgment making that call. What do you say?
Well, what I would say is that I think I would dispute the fact that all of the situations you just referenced as examples have a clear starting point. And I think COVID-19 is a good example. And I think, if we look at things like COVID-19 and, potential other pandemics, like, the big one that I guess people are worried about now is the measles pandemic. So it's not necessarily a clear specific event or I'll just leave it at that, a specific event that causes the start of an emergency. And, these questions like COVID-19 is whether that's an emergency, whether measles would be an emergency, is something that's become very sort of politicized. And so I think the question would be, if the governor were to, if measles, for example, were to take a big hold in the state, the question would be, well, is one case enough for an emergency? Is 10 cases, 100 cases? Does somebody have to die first? How many people have to die? I mean, those are questions that are very difficult to answer. And
the statute defines disaster as any emergency or imminent threat thereof which results or may likely result in the loss of life. I mean, measles, COVID, it appears to fall under the disaster issue, you know, the definition. But I'm sorry, I'm not sure you had finished answering the previous question. Please proceed.
So just to finish answering that question, I think if the court is to accept the idea, which admittedly is a necessary part of our argument, that there doesn't have to be one single identifying event for emergency to start, then I think the same has to be applied to the end of the emergency too. I mean, if a set of circumstances can, over time, develop to the point where it becomes an emergency, and that's a legitimate use of the emergency authority, then I think the same has to be true in reverse, where at some point, and that's up to the governor's discretion, those set of circumstances are no longer serious enough to continue warranting the emergency authority.
Well, let's take the Lahaina fires as an example. There was clearly a starting point, but there continue to be emergency proclamations. I mean, the determination as to when the emergency ends, I don't know that anybody can put a finite date on that kind of situation either. Even if you have a clear starting point. I mean, part of the challenge with this, and I think why the chapter is written in the way it is because it covers all manner of potential emergencies. And so I'm going to ask you this question. If this court determines that judicial review is important and necessary here, what is the standard that should be applied?
So I don't know if I can say exactly what standard should be applied, but I do think it would have to be a very deferential standard, whether that be arbitrary and capricious. It's probably the most likely standard. But there's a couple of reasons for that. And one is, as you mentioned, just the underlying purposes of HRS 127A, and the fact that the legislature made it very clear that it's not really possible to provide for every possible different type of emergency that might arise, or what type of scale those emergencies might be. And going back to the point I made earlier in terms of, with a pandemic, at what point does it become, how serious does the pandemic have to be? How serious does a particular disease have to be to warrant an emergency? How many cases does it have to be? Does it have to actually require that people die? And that, I think, is very much a determination of a factual situation. And I think that is another thing that makes that particular question ill-suited to the type of, to a legal question, which is essentially how it would be addressed under a action for declaratory relief. And so I think there does have to be a pretty large amount of discretion given to the governor, particularly in light of the language of 127A.
So if you're arguing that the governor should have discretion, why is it not an abuse of discretion standard?
Well, because I think the emergency situation is sort of unique.
All right. So, I think it's pretty clear that under the definition of disaster under 127A2, things like COVID and pandemics would be covered. We're talking about loss of life, disasters. But 127A1, in 2014, when the legislature adopted Chapter 127A to replace the former Civil Defense Act, it says policy and purpose. Because of the existing and increasing possibility of the occurrence of disasters or emergencies of unprecedented size and destructiveness resulting from natural or human-caused hazards, and in order to ensure that the preparations of the state will be adequate to deal with such disasters or emergencies, to ensure the administration of state and federal programs, et cetera, to protect the public health, safety, and welfare, and to preserve the lives, property, and environment of the state. That's the policy and purpose. Subsection B goes on, it says that it is further declared to be the purpose of this chapter and the policy of the state that all emergency management functions be coordinated to the maximum extent with the comparable functions of the federal government. All right, so which comparable functions of the federal government would be triggered here? Is that being coordinated under this emergency management function?
Well, I don't think that definition requires in every circumstance for there to be coordinated
Doesn't this indicate this chapter appears in Title 10 of the Hawaii Revised Statutes dealing with public safety and internal security? It's not in the chapter that deals with property and housing. And it appears that the intent of 127A is to deal with natural or human-caused hazards. The first proclamation talks about how we've had a problem with affordable housing since 1935. How is this a natural or human-caused hazard under the definition and the purpose of 127A?
Well, I mean, first of all, under the definition, so I would note that the definition of emergency does not actually include the word hazard in there. So that's not necessarily a part of the definition of an emergency. But, you know, I would just go back to the fact that, well, 2 points, I think. One is that I don't think there's really
What's the occurrence then? Emergency is defined as an occurrence. What's the occurrence? What's the triggering occurrence?
Well, the occurrence is the continuing set of circumstances.
How can a continuing set of circumstances be an occurrence?
Well, it's defined as such, and we cited that in our response to the amicus brief. It is defined in both Black's Law and in, I don't recall the other dictionary that we cited. Is one of the definitions is a continuing condition is the exact definition in that. And so it's not, you know, we don't believe it is necessarily dependent
means
on
any occurrence or imminent threat thereof. So imminent threat of and continuing set of circumstances?
an imminent threat to essentially public health and public safety. Yes, a continuing condition that threatens public safety,
which may result in substantial injury or harm to the population, or substantial damage to or loss of property, or substantial damage to or loss of the environment. It really seems to be talking much more about natural disasters or pandemics, things that are, I don't see how affordable housing falls in 127A.
Well, I'm sure when the legislature was writing this, I mean, the most obvious examples of disasters and emergencies people think of is
what limits would you place on a governor's power to declare emergencies if affordable housing is, you say, as you argue, falls under 127A? What limits, if any, would there be for any executive to exercise executive power to issue emergency proclamations for whatever ill or whatever problem society may have?
Well, whatever,
and suspend all laws.
Whatever situation or set of circumstances the governor identifies as an emergency, it's always subject to limitations. I mean, we're certainly not arguing that everything the governor does under his emergency proclamation is not subject to judicial review. That's not our position at all. You know, absolutely we acknowledge the governor cannot violate the Constitution with his emergency powers. He cannot violate federal law with his emergency powers. He cannot violate requirements in 127A through the use of emergency powers. And so everything that the governor does to put that emergency proclamation into action is subject to judicial review to the extent that someone is harmed or someone has a concrete enough interest in order to challenge those actions. So I would say there certainly are limits on the governor's authority. And I acknowledge it is a very broad grant of authority that the legislature has given to the governor. I absolutely acknowledge that. But I certainly would dispute the idea that there are no limits to that authority.
Well, let me ask you this. I mean, a little over an hour ago, Mr. Collins started his prefatory remarks with, you know, an analogy to what's happening at the federal level and certain things that have been challenged there. And I understand your office has joined hands with other attorney generals to challenge certain federal actions, things like the Aliens Enemies Act and perhaps maybe the Economic Act relating to tariffs and things of that nature. And I'm just wondering, you know, so you're taking this position at the federal level on these federal challenges that there is executive overreach, yet here at home, you're almost taking this maximalist approach to the authority of the executive branch. And I'm just wondering how you can sort of reconcile both of those positions.
Well, I mean, I can reconcile them because as far as I know, first of all, as far as I know, the actions the state has taken in response to the current federal administration's actions, that hasn't involved a challenge to the use of the president's emergency authorities. And second, in those cases where the state has taken some kind of legal action, it's been in response to an identified specific violation of a statute or a specific constitutional violation. For example, the birthright citizenship case. And you know, as I just mentioned in my answer to Justice McKenna's question, we're not disputing that those are not subject to judicial review here. We absolutely agree that if the governor declares an emergency and then does something which violates an individual constitutional right, they absolutely have a claim against that, and the governor cannot do that as the use of the emergency powers. And so, I think, I mean, that's essentially how I would reconcile those two different situations.
Thank you.
Would a developer that does not want to engage in affordable housing development have standing to challenge these proclamations?
A developer that does not?
A developer that does not intend to engage in affordable housing development have standing in the state's view?
Have standing to challenge the emergency proclamation?
Yes, because that developer would not get the benefit of the suspension of so many different laws.
I don't believe so. No, I mean.
So the developer would have to charge more for housing, might be priced out because of the affordable development laws, would not have standing. These plaintiffs would not have standing. I'm still trying to figure out who would have standing then.
I think that whatever that, I'm not sure I can say based on a sort of unknown factual circumstance, but I would say that the extent to which a developer like that has standing would be exactly the same as a challenge to affordable housing that is not done through the emergency proclamation. I mean, the state has various statutes and also ordinances on the county level that provide certain waivers for affordable housing, which have nothing to do with the emergency proclamation. And so to the extent that a developer has standing to challenge affordable housing developments under those, approved under those statutes, I think it would be largely the same under the emergency proclamation.
One more.
Yeah, thank you, Chief Justice. I wanted you to address the plaintiff's Article 1, Section 15 argument.
Yeah, sure. So, essentially, and I think this is sort of largely tied into the general separation of powers argument too. But essentially, to the extent that provision precludes the legislature from delegating the authority to suspend statutes, unless in such particular cases only as the legislature shall expressly prescribe. The legislature has done that here. The particular case that the legislature has expressly prescribed is when the governor has identified a set of circumstances that constitute an emergency. And so that's the first limitation on that authority. And the second is that the governor's authority to suspend statutes is subject to the requirement in 127A-13 that requires that statutes can only be suspended to the extent that they impede or tend to impede or hinder emergency response functions. And I think that is a very real limitation, because what it does is, and as I think as we can see in the emergency proclamations here, is that it prevents the suspensions from being overbroad. And so, like, for example, in these proclamations, the statutes are only suspended to the extent that there is a certified approved housing development, and only to the extent to allow the expedition of that housing development. So it sort of essentially prohibits, as sort of an example, if you had an emergency that occurred at Honolulu Airport, as to something very specific to the Honolulu Airport, the governor could not declare an emergency based on that and then suspend procurement laws for the whole island in any circumstances, because that suspension wouldn't be in line with HRS 127A-13, which limits it to the extent that it impedes the emergency response. So I see my time is well up, so I will just...
Any final thoughts or arguments for the court before we go back to Mr. Collins?
No, I would just wrap up by saying that because plaintiffs do not have standing to obtain declaratory relief in these circumstances, and because we believe the governor's exercise of his emergency authority was proper, we ask the court that the court affirm the circuit court's dismissal of the amended complaint.
All right, thank you, Mr. Rayner. Mr. Collins, I will give you, if you need at least 5 minutes or more, that's fine.
Okay, I'll try not to use
We went quite a bit over for Mr. Rayner, so I want to be sure we're fair to you and give you the opportunity to argue, but try to keep it more in the 5 to 6 minute range if you can, but we'll see how we do.
Thank you, Your Honor. I would just like to respond to a few points. The first is, as my colleagues have identified for me, that Act 206 of 2024, which was adopted after this case was resolved at the circuit court, also amended, it did amend parts of 127A to address this continuing or the renewal of proclamations, but it also said that 127A should not be construed as conferring any power or permitting any action that is inconsistent, and it says the Constitution and the laws of the United States and the Hawaii State Constitution. That's at the very beginning of 206, and then the language about the continuing proclamations or the renewals is at the end of 206.
In terms of your as-applied challenge, based on Article 1, Section 15, how, and it kind of relates to the standing argument, how are your clients harmed by this?
So, Your Honor, our position with that is that the declaratory judgment action says that that a declaratory judgment action can be brought without requiring one of the parties interested to so invade the rights asserted by the other. And our view is that declaratory judgment actions used to be used, not very often anymore, to challenge unconstitutional criminal statutes. And that doesn't require somebody to be subjected to a criminal prosecution in order to have the court determine that a statute or an ordinance is unconstitutional. And in this case, the shifting of the proclamations shifting of 205, 201H, and 46.4, it does affect the property interests of the plaintiffs. To their
so you are asking us really to rule more on the first and or second proclamation, the proclamations that were in effect at the time that you filed your complaint and or amended complaint.
Well, the current proclamation still, it still modifies, it suspends and modifies. I'm not sure if it really suspends because it really just modifies 201H, and it still suspends, it still suspends and modifies the civil service procurement code and school impact fees. And in paragraph 15 of the amended complaint, in addition to raising the clear and healthful environment and First Amendment, at the very end, it does make an allegation regarding the kind of economic harm which is required to be pled for taxpayer standing. And it's specifically in paragraph 15. And our view, to address my colleague's point, is that Rule 6 really only requires a short and concise statement of the claim. And the plaintiffs here were not required to list every fact, but they alleged, it was very clear, here's the proclamation, and here are our interests that are threatened or invaded by this proclamation. And they shouldn't have to wait until there's a specific development. I mean, one of the outcomes of the 201H process is that it's not approved.
Well, but you're challenging the proclamation's amendment to 201H, is that right?
Yes, we're challenged to 201H to Chapter 76 to 103D.
All right. You're not challenging 201H38 and what HHFCDC can do under 201-H-38 because HHFDC has authority to suspend laws on its own accord.
Yes, for its projects.
Right.
And I know it's also been interpreted for independent projects in some way, and that's never really been reviewed by a court. But yeah, the HHFDC, that statute mostly is HHFDC, but it's the provision that basically removes the one area where the county councils play a role in the review and approval process, which is my client's position that it both impacts the clean and healthful right to a clean and healthful environment and also their First Amendment rights to petition the government because, of course, they testify, they do their petitioning, and if they don't like the outcome, then they can go to the ballot box and try to address their concerns there. But by removing that from the elected officials entirely without the legislature making that determination, it's completely deprived the plaintiffs of their ability to petition the government. It's just been completely shifted over to an unelected body.
Mr. Collins, to the extent that the right to a clean and healthful environment might be implicated, for example, by suspending 46.4 HRS, would that give standing as to all of the other claims made by the plaintiffs, or would it only relate to the claims that are based on that suspension? In other words, does that, once the door to standing is open, is it open as to all claims in the amended complaint, or only as to those that are specifically implicate the right to a clean and healthful environment?
Well, our position is that we have pled harms to several different things. So for like civil service, procurement.
I understand. I'm just assuming if we focus on that, how far does that get you? If we focus on the right to a clean and healthful environment, once you have standing as to at least a portion of the proclamation, does that establish standing as to the rest of the proclamation, or do we need to look at the other theories that you've directed us to?
I think for purposes of determining that the emergency that was declared that does not comply with the statute, it may not necessarily be to have to address each of those things, but I think we've met standing for each of those things, and I mean each of the procurement, the civil service, all of them have very different. They address different harms, but they all lead to the same path, which is that the proclamation was based on an emergency that isn't under the statute.
Very well.
I wanted to say that and I'm not sure if I'm addressing this exactly correctly, but our view is that if fundamental rights are involved, that strict scrutiny applies, and if it doesn't affect fundamental rights, then the standard of review for the governor would be a rational basis. And in Territory versus Yoshikawa, the question of an emergency was a fact issue that was heavily disputed. But in this instance, I don't think there's a factual dispute among the parties about what the underlying facts are. And so it's up to this court, and I think it's by preponderance of the evidence, or something along those lines, for the court can use its own common sense to determine whether factually there was an emergency. One more thing I'd like to note before I conclude is that in Youngstown Steel, Justice Jackson, and Youngstown Steel was decided 2 years after the 1950 Constitutional Convention. Justice Jackson in his concurrence noted that when the Weimar Republic adopted its constitution after World War I, the rights of its citizens were suspended 250 times. And then he says, finally, Hitler persuaded President von Hindenburg to suspend all such rights, and they were never restored. That may sound far-fetched, but only if this court affirms that emergency powers have enforceable boundaries. That principle is deeply rooted in Hawaii's constitutional history. And the Constitution responded to that history by making one thing clear, that laws may be suspended only in particular cases expressly prescribed by the legislature. And Chapter 127A, in our view, as written, reflects that caution. It does not grant open-ended power to address policy crises, no matter how pressing. The legislature is the moral conscience of society, and housing policy is fundamentally a legislative issue. Declaring it emergency does not convert it into an executive one. And I would like to conclude by quoting Justice Frankfurter's concurrence in Youngstown Steel. The accretion of dangerous power does not come in a day. It does come, however, slowly from the generative force of unchecked disregard of the restrictions that fence in even the most disinterested assertions of authority. We ask this court to sustain our appeal, reverse the circuit court, and hold that the governor's declaration of an emergency exceeded his authority to do so in this case, and remand to the circuit court with instructions to enter judgment in our favor. And on behalf of Bianca Isaki, Ryan Hurley, and Linda Nye, and myself, we would like to state our gratitude to the Chief Justice for his service to our community. Thank you very much.
And thank you to each of you for your arguments today. And I think this is an example of our judicial process operating at a very high level. So thank you to both of our attorneys for your very well thought out arguments today. The court's going to take this matter under advisement. Aloha.
A ku iluna, please rise. Ua ho'oku'u ia mai ne ke aha ho'okolokolo ki ke hanahano okomoku aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.